Yes, welcome to the No State Project. I'm your host, Marc Stevens, author of Government Indicted, available at markstevens.net. We're here for 3 hours live from the fortified compound in Mesa, Arizona. 3 hours of anarchy radio right here on the Liberty Radio Network, LRN.FM, where we're here live most Saturdays, but we usually at least have some new material. But today we all live. It's July, just so you know, because I've said that before. It is July 1st, 2017. If you want to join me on the big show today, it's 218-632-9399, 218-632-9399. The passcode is 2020 and the pound sign. And since it's July 1st, that means we have 30 days. That is just at the end of the month for the start of the Jackalope. The 6th annual Jackalope Freedom Festival in Bacchus Meadow, which is about 2 hours, let's say, northeast of Phoenix, where it will be the usual beautiful, about 82, 85 to 85 degrees. Beautiful. It is not going to be 115, 116 degrees up in Bacchus Meadow. So definitely plan to check that out. It looks like fairly confident that Calvin will be joining me there again, so we're looking forward to that. So remember, the Jackalope Freedom Fest, July 31st to August 6th, and go to jackfest.rainberry, and that's rain with a Y.com. You can, it's linked on markstevens.net, or you can just look up Arizona Jackalope Fest 2017, and you'll be able to get there immediately. I want to thank everyone for the continued support of the broadcast. Do appreciate that. This is the first live broadcast that I've done here on LRN with about half the home studio soundproofed. So I got a pretty good deal on acoustic panels. I want to thank Chris for that. So I think that, it sounds to me anyway that we, so far I think we got it's sounding better, but we still have some more space to cover. We'll get to that. And speaking of support, and I'm not leaving anybody out, but the reason why I didn't do a live broadcast on Wednesday was because that was the day the Maiden show was. So, if it's a choice between doing a show and going to see Maiden, I'm going to go see Maiden every time. Every time. My hearing is back to normal, which is good because it would have been difficult doing the show after that. But big thanks again. I got to meet Don in Tempe, who provided the tickets. And I thought it was a fantastic show. I really appreciate it. It's Maiden. What can you say? But I brought my daughter's first concert ever was Iron Maiden. So that's it was interesting because all of us who were kids, teenagers, when Iron Maiden was hitting their peak in the 80s, a lot of us have kids now. And so I was not the only one bringing one of my children to the show. There was actually somebody whose father had brought him to his first show was Iron Maiden. This is over 30 years ago. And so he brought his son to see Maiden, and that was his show, and the kid was 8. That's getting the kids started off right. 8 years old, not able to see a better concert. So, but it was. I was a little disappointed that they didn't play a lot of the older stuff. I'm glad somebody there was wrong because they said that they saw the playlist. There was only 4 of the older songs. Thank goodness that was wrong. But there wasn't many. They played one from Iron Maiden, which, of course, they ended the regular part of the show with. They've always done that. They did one from Killers. They did, they did one from Killers. They did 2 from Number the Beast, 1 from Power Slave, and 1 from Somewhere in Time, which, honestly, they could have just done another one from Power Slave or Number the Beast. And someone told me outside that there's some legal battle that they can't play Hallowed Be Thy Name anymore until some court battle is just leave it to the courts to screw up something like Iron Maiden, the bastards. So I don't know what the deal is. Maybe something over the lyrics. I don't know. If somebody knows, maybe they can give me a call and let me know. I do want to point out, maybe someone's got some information about this because I haven't been able to get much information on it. On my markstevens.net email, I'm probably going to have to stop it soon because I get 400 spams a day. And it's not that they're all from different email addresses. They're just doubled and tripled, and and so every time an email comes in from a spammer, I get 2 or 3 of them or more. And I don't know, maybe it was a mistake that I made. Maybe one of you tech guys out here can help me out. I started, while I've been on hold, doing something, and so what I started doing was going through and unsubscribing to the emails. And the flood hasn't stopped. I'm getting just as many emails. The problem is, I've never seen this before. There's no content to the email at all. There's nothing in there. There's just a header. So it's spam, but there's no text, there's no links, there's nothing in there. So I don't know. I've not seen that before. So now I can get 400 emails in that inbox, and there's no content to any of the damn emails. So I don't know. Did I make a mistake going to unsubscribe? I don't know. I probably will stop using that email and then post a new email address, or just stop using it altogether, because it's just all I do. I get maybe 5 emails a day from that are actually legitimate emails, and the 400 or 500 are just spam. So, but you want to join me on the show? 218-632-9399. 218-632-9399. I'm not going to. I appreciate the people calling in. And I just beg your indulgence and your patience. I don't like to start a call in the first segment because it's so short. But what I want to discuss is I appreciate all the support we've been getting recently on my YouTube channel. The last video I did was, and I mentioned this before, that it had to do with what happened to our Paisan Bill up in New Hampshire. And it was actually a part of a broadcast a couple of weeks ago. And something happened when I edited the video together. I had to redo it. And so I couldn't release. I was even later with the damn thing. So I finally was able to re-edit the video properly. And with some tech help, suggestions from Calvin, boy, that really, really helped. I mean, really helped. So I'm doing that from now on, so we won't have that same problem. But what happened was none of the graphics were. It was so heavily pixelated, so badly pixelated, you couldn't read them. So that's why I had to wind up redoing most of the graphics for that. But it actually, for one of my videos, is actually getting more views faster than any other previous video I can think of. So it already surpassed the other 2 previous videos, which actually did kind of well for my channel. So I do appreciate that. Getting near 9,000 subs, so let's see if we can make that happen soon. And speaking of Maiden, I wanted to mention, I finally got to see. I had written that down, but I didn't mention it when I brought up Maiden. I finally got to see the movie Where Eagles Dare. So if you're familiar with Peace of Mind, you know that that's the song that starts that CD, and it's awesome. It's like, well, how can it get better than Number the Beast? And then, Where Eagles Dare starts the CD, and like, oh, okay, I guess they could. Same thing with Power Slave. You start Power Slave, and it starts off with Aces High. Holy crap. Excellent movie. I got to see it on Memorial Day when all the war movies are on. Excellent movie. I can see why Steve Harris would have written a song about it. Glad he did, and he didn't have to wait till he was my age to actually see the movie. I have a new segment or a new series of videos that I am going to be doing, and I got the idea because I missed one of the graphics in the latest video, and it gave me the idea for a new series of videos. They'll only be 5 to 10 minutes long, but they're only going to be focusing on one bureaucrat and exposing them. But I'll talk about that more when we get back here on the big show. So we got a lot to get to, so don't go away. Yes, welcome back to the No State Project here on the Liberty Radio Network. I'm Marc Stevens, author of Government Indicted, which has a full model on how to effectively defend yourselves against these tyrannical people, these predators. So, real quick about the new segment, I'll talk about that more in depth later, but the idea came to me when I couldn't believe I missed one of the damn graphics. And it happened to be a bureaucrat, of course, New Hampshire. And so that gave me the idea to do shorter videos exposing bureaucrats so that when we have more search results, so when their friends and family are looking them up, they will get to see and sometimes hear what their friend or family has done. So this particular one has done irreparable harm. And he's kind of the good cop, because he was the one with the patience. He was the one that was just, God help me, get me through this call with Mr. Stevens, and just so I can go home and have a beer. And that's what made it seem almost worse. So he was no Ray Persinger. And we'll have a video about him, too. So if there is a particular bureaucrat, I'm not talking about the well-known ones that everybody can Google and find information. I'm talking about the low-level grunts, the ones who are operating in almost complete anonymity, like the Sophie Tittles of the world, the Joseph Teddys. That's what I'm talking about. Or one of these low level, and judges in particular. Judges typically operate in obscurity, and it's very difficult to get pictures of them. Very difficult. But at least at the federal level, you can get some pictures. I was able to get Michael B. Thornton because he was confirmed for the tax court, so there was a video of his confirmation hearing. Because generally, you can't get pictures of judges. Very, very difficult unless they were high-profile prosecutors that were in the news. So I'll get to that and more, but let's get to your calls. We got new callers today. Area code 707. What's your name and where you calling from?
Hey, Mark. My name's Jordan, and I'm calling from Davis, California.
Gordon from Davis?
Jordan from Davis, California.
Oh, I really screwed that up. Jordan from Davis.
Yes, sir. How are you?
I'm doing well. I got a paisan over there in Davis.
Oh, nice.
So, Doug, who's an anarchist and a vegan anarchist now, lives in Davis, I believe. At least he used to.
Awesome. So how's your day going?
Did you just say Dago?
No, I said how's your day going?
It's a little joke. Didn't go over well, so hey, everybody, I'm good. Good night. All right, what do you got for us today? What's going on?
All right, so I recently, actually, just last night or yesterday, I purchased your demur, your documents for demur to get a ticket dismissed. So for a while, I've actually been on YouTube, and I came across your videos a couple of times. And I ended up ignoring them because I thought that your plan was just super, super simple. I thought it was way too simple, and I was like, okay, I'm just like gonna keep on looking, and somehow I got brought back to your video through another video because the guy's like, oh yeah, like these templates work and everything, and so I was like, okay, you know what, I'm gonna give it a try. And immediately when you sent me the templates, I just noticed that I know that they're going to work because you have so many good reviews on them, and I watched a lot of your videos last night. But my particular situation is that I have 3 tickets pending right now, 3 speeding tickets at that, and I got one of them last night, and then I got 2 of them back in February. And the 2 back in February, I fought through trial by declaration, and one of them, as of now, has gotten denied. And then the other one, the cop did respond because I just called the court a couple of days ago, and so I'm pretty sure they're going to deny that one as well. But the other one, so the one that has already been denied, I requested a trial de novo so that I can have another hearing or whatever. And my question is, would filing the demur and the other motions be applicable?
Well, yeah, it's a trial de novo. It's starting over again.
Okay, cool. And then my other question was when you provide copies, do you change the address every time? So, like, for instance, do you like when you make the copies or serve the documents, do you make one out to the court, one out to the police officer and his department, and then one to the prosecutor if there is one?
Whoa.
Or is it all just one address?
Well, you don't have to put the court's address on the certificate of service because you're not okay. That's only for the opposing side, not for the court. So typically, people will send me the document to review, which I'm happy to do, and at least half the time they're putting the clerk of the court in the certificate of service. California, anything that they can find to reject the paperwork, they're gonna use. So I suggest making sure that everything is done correctly. The clerk of the court gets an original and a copy. They get an original every time. But you do not put the clerk of the court's address in the certificate of service. You put the police officer's address, and you said his apartment. Or no. And just under no circumstances are we ever to try to find the police officer's home address. You just don't even bother trying. You send it to him at the police department. It's a work thing. It's not a personal thing. So he did it while he was on work. It always goes to the police department. If there is a prosecutor assigned and you have evidence of that, never send it to the police officer. Only send it to the prosecutor. So in this situation, you send it. If there's no prosecutor, you send it initially to the police officer. If the police officer isn't going to be acting as prosecutor and doesn't want anything to do with it, he may pass it off to a prosecutor who then will give a notice of appearance, and you will get paperwork, and you will know his name or her name, and you'll have an address to send it to. And then you put that into the certificate of service.
Okay, so my other question is, in the state of California, is there no prosecutor in traffic court?
It depends. A lot of times there's not. If it's a speeding, there probably will not be a prosecutor unless it is considered criminal speeding. So, but you just hold tight. We're up against a break. Jordan, my name's Marc Stevens. You're listening to the No State Project here on the Liberty Radio Network. We will be back with your calls because we are getting loaded up in just a moment, so don't go anywhere. Yes, welcome back to the No State Project. Remember the website, markstevens.net. Well, maybe Jordan will be one of the newer success stories that we have there. I do want to discuss, Jordan, with you regarding... I don't want anyone to get overconfident that just because the paperwork looks good, that means that they're going to fall over themselves thinking this is brilliant. And even when they have said that it's written very well, it covers all the bases, it's solid, they just deny it without explanation. Anyway, so you still have a battle that you should be preparing for. It should never be, I've got great paperwork, and this is going to be easy, because it isn't always easy. It was nice for Corey that the cop didn't show up after all that. And, of course, there's criticism that it had nothing to do with Corey's defense. But, hey, okay. But, hey, if you could do it in Blythe, California, you can do it in Davis. But just know that you are in for a battle with these people. So it's never easy, no matter how tight the paperwork might be. Okay?
Huh. Gotcha.
Yeah, I mean, you want to over prepare, you want to make sure, and there's always a good chance, that the police officer will take a look at the paperwork and say, "Screw this, I am not bothering with this guy." It doesn't mean that the police officer necessarily sees merit to it, because, frankly, I don't think the police officers can understand well enough to know if the paperwork has merit.
Yeah, I agree with that, definitely.
You know, and I
And
don't.
it was so fun because yesterday I got pulled over and I saw the cop's lights and he was like basically tailgating me, and it wasn't clear enough for me to pull over to the right, and then he turns the sirens on and he says pull over, and then so I'm like what the heck, like because there's still cars in the right lane, so it's not like I could just jump right over in front of them. So I pull over to the left, and then he follows me to the left, and then he gets on his intercom and he's like, pull over, take off the exit, don't ever pull off to the left or whatever. And so I'm like, I don't want to be pulled over on an exit where there's like nobody that can see me. You know what I mean? Like, especially these days in police brutality and people getting shot or misunderstanding. So I pulled off the exit, but I pulled onto another street, and he got so mad about that. But I told him I'm not going to pull off on the exit where there's no witnesses around. And he yelled at me and said, "Oh yeah, I'm writing you for the violation of pulling off to the left." And I was like, "Okay."
Okay. Did you answer any of his questions?
No, I did not answer
Good.
any of his questions. And then when I signed the citation, he said, "Oh, like sign here." And I said, "Okay." So I put under duress, and he asked me, and he said, "Oh, why'd you put under duress?" And then I said, "Thank you, officer." And then and he said, "Why'd you put under duress? Like, I already told you that you're not admitting to guilt." I was like, and then I just told him, "Thank you, may I have my citation, may be on my way." And he got pretty pissed off about that too, and he just like ripped it off and just hit it to me and said, "Wait until I turn my brights off before you leave," or something like that.
You have to put, and it should be on the discovery request. You need a copy of the back of the ticket that he gives to the court.
Oh, okay.
Do you know why?
A copy of the back of the ticket?
Yeah. Do you know why?
Never knew about that. No, why?
Because when he went back to this car, he was writing up what a scumbag he thought you were, and that the judge should throw the book at you.
Oh, I see.
He has probably made you out to be public enemy number one, that you were the worst of the worst he pulled over that day. This guy had the audacity not to answer a direct question. And do you know that not one person has ever reported to me, and maybe this is something that we have to keep bringing up, you have to get a copy of the back of the ticket so you can see what notes, if any, the police officer made. And no one has reported to me yet that they've actually gotten a copy of the back of the ticket that was filed with the court.
Yeah, I never knew about that. That's crazy.
Yeah, I found out about that years and years ago. It came out on some documentary about 15, 16 years. I forget exactly when. And it turned, some major news network was doing an expose on shady traffic courts and police brutality. And I'm like, oh, that's why some judges are total scumbags and don't give you an inch. That son of that damn cop wrote notes that you don't get to see.
Right. And that is so crazy. Oh, my goodness.
And I had brought that up, but not forceful enough in my last trial. And so once we started getting into it, I said, "Hey, wait a minute. I never got a copy of the back of the ticket. I'd like to see it." He says, "Sir, we're done here." I said, "But I brought that up prior to trial." "No, we're done."
Wow.
Yeah. So, so that's why you did fine. You didn't answer the questions. And now you may be able, if there are notes on the back where he's slamming you, you may be able to use that to your advantage on a cross-examination. Don't I have a right to remain silent? Then why did you get so upset and say this about me? Because I wouldn't answer your questions. Yeah, jackass.
Right. Interesting.
Yeah, so everyone keep that in mind, and I'm pretty certain it is in the discovery request, but it's something we have to make sure that we're bringing up when they actually bring us to trial. So prior to the trial, we have to be able to see a copy of the back of the ticket.
Gotcha.
Well, because cops are such nice guys. He's only concerned about public safety. Yeah, right.
Yeah, seriously. Like, and it's so intimidating when they pull you over because they're not there to be your friend. Like, they're just there to harass you in a way.
Yeah, they are there to extract money from you. And I will say this. It's really easy to avoid most speeding tickets. I purposely, when I go to California sometimes twice a month, and having an Arizona plate, I stick out like a sore thumb. If there's 3 people speeding and one has an Arizona plate, damn it, they're going to get the Arizona guy every time because they're not going to want to have to come back, especially if you're going through Blythe. Who the hell would want to drive back to Blythe, right? I always make sure I go a couple of miles an hour under the speed limit. I don't change lanes unless I absolutely have to. I do nothing as far as I can as practical to give this guy any reason to pull me over. Anything. I even keep my headlights on every moment
in the daytime.
Yep. And not because I got stopped in California. My wife was coming back from California, and she was going through, it was right before Quartzsite. And she didn't have the lights on because it was like an hour before it got dark. So let's say now it gets dark at 8 o'clock. So let's say it's like 6:45. It's still bright and sunny out. And you're in the Arizona desert. There's no clouds. It's bright and sunny. She got a warning that she didn't have her lights on.
Wow.
Yeah. So speeding. There's better ways if you're doing it as an activist. Don't do it as far as speeding. Just turn the license plate over. You'll get a ticket. It's much easier. Or get a parking ticket where there's no threat. The violence is a lot less. Speeding.
Right.
It's not worth it.
Gotcha. And in California traffic court, it's kind of weird because, when I called the court and they said, and I asked, is your guys' traffic court, when you guys deal with your traffic courts, is my ticket, and then is it a civil infraction or am I being charged with the criminal offense? And they said, no, it's just traffic. And so, basically, they don't want to answer it. And I'm like, no, it's either civil or it's criminal. So which one is it? And nope, it's just traffic. And I'm just like, okay.
Yeah, that's why we usually ask them, and it's in the script. You ask them what the burden of proof is.
Gotcha. And there's a script.
Yeah. So we encourage people to get the script and get into the Skype chat to do the role playing.
Okay. And where's the script? Is it the same place where I got the motion?
Yeah.
Okay.
This is odd. I should mention this, but we are off air right now. The network is having problems, so we're just going to keep going.
Okay.
Well, we're gonna keep going. So did you? Because I still have other callers. So whenever we connect back to the network, hey there, we're actually off air. Well, okay, so we're during commercial. So you just hold tight. We got a couple minutes, and then we'll come back and we'll finish in the next segment. Okay.
Okay, sounds good.
All right, we'll be right back. Yes, welcome back to the No State Project. I'm Marc Stevens, author of Government Indicted, and thanks to Calvin, I think I'm going to see how the audio is. Nonetheless, it will be linked in the show notes, but he sent me a link for a news report of cops and judges caught using secret codes on tickets. So I haven't heard this one, but it came from Calvin, so hey, I'm sure it's good. So hopefully the audio is good.
Officers pulling over South Florida drivers, giving them tickets. But those tickets have a secret signal that may drive you mad. It's a 7 News exclusive investigation. Hello again, everyone. It's tonight's top story.
A 7 News investigation exposing an unfair practice that is taking place every day in traffic court. Investigative reporter Carmel Cafaro has discovered officers are having secret ticket talk with judges, and it could affect your case.
It's the point no motorist wants to see. But when an officer pulls you over, there could be something extra written on the ticket that until now the public has never seen. 7 News has discovered drawings like these on the back of some traffic tickets issued in Broward County. We're told officers draw a smiley face for a good attitude, a frowning face for a bad attitude, and if an officer thinks you're a real jerk, he might draw this.
To the court, that, and to him, that means flaming A.
The people that come into court with those notes on the back of the ticket have no idea that that accusation's been made.
This is an original ticket, and this is the front of the ticket, and that's what you get. But attached to that, although not separated here, is the other part of the ticket, which you don't see. That part of the ticket contains the drawings. It can also include additional notes detailing the officer's version of what happened, and that is what is sent to the judge or magistrate.
I'm going to treat everybody fairly.
Problem is, when a motorist goes to court, he or she has no idea the magistrate has that extra information.
I came off Commercial Boulevard, and I made a U-turn. I said,
Sharonda Barker decided to fight her ticket in court. She even brought in pictures to try to prove she did not make an improper turn.
I feel that the state has met its burden of proof.
She lost her case. She had no idea the magistrate had this, a copy of her ticket with a frowning face, until I showed it to her. Did you have a bad attitude?
no bad attitude at all.
But don't you think, looking at this, the judge might have thought otherwise?
Exactly.
You think it's unfair?
It's unfair. Absolutely unfair.
Your Honor, could I have the ticket in the court file, please?
Ticket attorney Marc Gold challenged the practice after we asked him about this ticket issued to one of his clients for running a red light. On the back, a frowning face. BSO Deputy Mark Schaefer wrote the ticket.
And what does a smiley face or an unhappy face mean?
No problems, non-combative, just pleasant.
A smiley face and an unhappy face means?
Somebody wouldn't have to get their ticket.
Gold asked the magistrate to dismiss the case based on improper communication.
Now, how can a judge be impartial if they've already heard one side of the story and they heard that the officer said this person was uncooperative or had a bad attitude?
The magistrate wouldn't drop the case, but decided to hold off on making a ruling.
I'm going to do further research on that issue and then come to a decision.
Nova Southeastern ethics professor Bob Jarvis didn't have to research the issue. He says any first-year law student could tell you this practice is wrong. So how is this going on every day in Broward County courts?
I frankly don't have an answer for you. It is shocking to me and very surprising.
Even Chief Judge Victor Tobin was surprised when we told him about the practice.
It's not good. We shouldn't be doing it.
As a result, Judge Tobin says in the future, officers cannot put faces on tickets, and they will have to keep their notes separate from the tickets so the court doesn't see them.
It will not continue, in my opinion, as it is now, because I'm going to tell them don't do it.
As for the tickets currently making their way through the courts, the Chief Judge says he'll make sure defendants know if there's ticket talk on their citations. Carmel Cafaro, 7 News.
And that's that. So, yeah, they're just going to stop because you say to stop. You know, what I like is how they showed the judge there, Jordan, and she, even knowing that, she still wouldn't dismiss it. These people are such slime bags. They are such criminals.
Right.
Even
That's so
showing
crazy. And it's funny because we were just talking about this.
Well, that's because, you know, Calvin has sent me the link during the break. So, yeah, that's because we brought that up. So, yeah, you definitely want the police you want the police officer's notes. You want to have the back of the ticket. And so, were there any other questions that we can help address?
So your script. So I'm kind of low budget right now, but I plan on buying all of them eventually. But as far as my situations and speeding and being in California, would the civil one be the most helpful to me as of now?
Well, actually, for most government attacks, the criminal one is the only one you need. The criminal one is going to go through, and in working with that, is going to give you the basis in the tactics that we're using. So you'll understand the tactics. So regardless of whether it's deemed civil or criminal, you'll still be able to make effective challenges, because it all is hinging on the same claim anyway. The police officer believes that because you were physically in Davis, that their magical laws apply to you for no other reason than you were physically in Davis, and there's no evidence to prove that, whether they call it civil or criminal. The foundation is what we're attacking. We're collaterally attacking, for those who know the difference, and because the foundation is the same, however they denominate it, it's still an effective way to go. The only difference is there's a few different words, and the burden of proof is different. They still have a burden of proof, which they're incapable of providing, and are so arrogant, think that they don't have to provide it. So that's why we can go in no matter how they denominate it. The foundational claim is false.
Okay, gotcha.
Because you have a corpus delicti, or you have, and you have the same thing in substance. You have the injury and the damage, injuria et damnum. You have that whether it's civil or it's criminal. So because it's a civil or criminal is just an part of the adversary system, and to be adversarial, you have to have an antagonistic assertion of rights and damage. Someone has to claim that their legal rights were violated and they were damaged. So that is the same whether you call it the corpus delicti or you're talking about standing in a civil case, or you're talking about a valid cause of action. But a valid cause of action comprehends all civil and criminal, and the only difference between a crime and a tort is that there's jail time attached and it's brought by a state attorney. That's the only difference. It's exactly the same in form.
Okay. Cool. And we could send you the template, or like when we filled out our motions to make sure everything looks good.
Yeah, you can do that.
Awesome. Well, thank you so much, Mark. I really appreciate it.
You're welcome, Jordan. Stay in touch and get into the No State projects. Yeah, get into and start doing some role playing.
Okay, sounds good. And how do I do that exactly? I just go on
go to markstevens.net. There's a link directly to it under upcoming events.
All right. So markstevens.net. Okay. And then activism. The NSP Skype group chat?
That's it.
All right. Awesome. And how does that work exactly?
You just hit the link once it pulls it up, and you got the Skype window there. You just say, "Hey guys, I'm Jordan from the show, and I would like to get into the role playing." They usually do it right after the show on Saturdays. They do it pretty much every day, but usually, it's almost always after the show. So I recommend that for everybody.
Okay, sounds good. So if I buy the script now, would you email it before the show ends?
Sure. Yeah, I can do it during a break.
Okay, awesome. Thank you.
You're very welcome. All right.
What you're doing is awesome. I really appreciate it, because there's not many people that would do what you're doing. So you're doing great things.
Well, I appreciate that.
Good karma comes back.
I'm glad. Well, yes, I got to go see the Maiden show on Wednesday. So that says it all. John, I appreciate the call. My name's we're up against the top of the we have a top of the hour break, which should be any moment. But if you want to join the show, it is 218-632-9399, 218-632-9399. You can also get me on Skype by instant messaging me at Frank Rizzo 3. That's Frank Rizzo with the number 3. Don't just call me during the broadcast. Instant message me first, and then we'll bring you up. We'll be back in just a moment, so don't go away. Yes, welcome to the second of 3 hours of Anarchy Radio here with the No State Project on LRN.FM, the Liberty Radio Network, where you can tune in every Saturday from 1 to 4 Pacific Time, 4 to 7 Eastern Standard Time. And it's Sunday morning if you're down under, and I appreciate all those tuning in from down under, and appreciate Matthew's support of the show. If you want to join me on the big show, it's 218-632-9399, 218-632-9399. The passcode is 2020 in the pound sign. And I'll bring you right up. You can also instant message me on Skype at Frank Rizzo 3. Can you imagine how many Frank Rizzos are on now? If when I did that in 2006, there was already there was 3 of them already, which is, well, so the original 1 and 2, and then I got 3. Seemed to be fairly popular. Okay, let's get back to the phones. We have another new caller at it's area code 209. You're live on the No State Project. What's your name? Where are you calling from?
Hello?
Yes. What's your name? Where are you calling from?
Maggie from Chilliwack, California. And I have a no seatbelt ticket that I have to go to in about a week, and I mailed in the recommended motions that you have. And I guess what I'm still fuzzy on is like which ankle should I start chewing on first if the cop actually shows up in court.
Well, I don't think I've heard it put that way before. Did you say?
I heard you say in several different videos I've been listening to you for a while that you've taken different tacks, different approaches with the officers, and I'm not exactly sure. From the one about jurisdiction, what evidence do you have that just because I'm in the state of California that the laws apply to me? Or there was one when you said that you should ask him if he filed the cause of action, and then ask him how many parts there are to a cause of action, and then at that point the prosecutor or judge is supposed to stop him from answering the question, which I'm not exactly clear on why that would happen, why they don't want that question answered.
Well, sure.
And at one point you even said, talk to the judge about, I'm entitled to a fair trial, and you had a whole script, and then it was like, if the conflict of interest is found, you're going to address that before anything moves forward, and then you bring up the fact that who do you represent to the judge themselves, right, which would be a conflict of interest because they represent the state of California, right? Am I understanding this correctly?
Yeah. Okay, well, let's take did you say your name was Betty?
Maggie, Maggie.
Oh, I'm sorry. Okay. All right. Well, the first one, I just want to preface it by saying we typically don't lead off with that stuff because you generally don't have enough time. But we'll discuss it because sometimes you do get into that. Sometimes you have someone like Greg Ives who is playing the nice guy and knows in advance he's going to rule against you and will just humor you by sitting there and trying to answer some questions. So what you're talking about is asking a police officer who's writing the complaint and filing with the court, is you're asking him, based on what he did he file a valid cause of action? Because it's an adversarial system, and for the court to have jurisdiction, there has to be a valid cause of action before it. And when you ask him, did you file a valid cause of action, he will always say yes. When you ask how many elements are in a valid cause of action, which is a standard follow-up question on cross-examination, it goes to prior statements. He just testified to that. Competency and credibility are always a part of a cross-examination, regardless of who lies to you about it, okay? So keep that in mind. Competency and credibility is always a relevant subject for cross-examination, and his prior statements are always relevant for follow-ups. Okay. The reason why when you ask how many elements there are to it that they don't want him to answer that question is because he doesn't know. And it's going to show that he's not qualified to determine whether there's a valid cause of action set forth in the ticket. So he's not qualified to write.
So he's not actually filing, he's just lying to me in court. He's perjuring himself.
If he says yes, that he filed a valid cause of action, he may not necessarily be lying because he may actually think he did right up until the moment you ask him, hey, how many elements are in a valid cause of action? Up to that point, he may not have given it any thought. It's like when I was mentioning to Jordan earlier, I don't think these cops have the intellectual capacity, and even if they do, to understand these things, I think they're so arrogant that they can't admit that they might not know what they're doing. And so here, the prosecutor and the judge have to come to his defense, because if he answers, I don't know, he's admitting he's not qualified, and that negates his prior statement that he did file a valid cause of action against you.
Well, so he lied.
No, lying is when you're intentionally deceiving somebody. And here, I would rather err on caution and say that he's doing it out of he's not intentionally doing it. I think he honestly believes that he filed a valid ticket against you. He just doesn't understand what constitutes a valid ticket. He doesn't understand enough. He only knows what he has been taught. Now, if you go through this with him in court, and on cross-examination it comes out he doesn't know, and he writes you another ticket, and then he gets on the stand and you ask him that question, now he's lying. And he's knowingly committed fraud. He's written a ticket and filed it with the court knowing it wasn't valid. But the first time, I give him a pass as far as lying. He's certainly being dishonest by going out and believing he has jurisdiction over you. Hell yes. But
yeah.
So I would give him a pass on that the first time only. After that, he knows. You've educated him. He knows. As far as the other part, very good questions. I included part of it in Government Indicted, of course, and part of a transcript with Vin James, because it is a very effective way. Now, keep in mind, you're just asking these questions. And so the questions are for those who are new. Am I entitled to a fair trial? Now, the judge wants things to look good. He's going to say yes. Yeah. Well, can I get a fair trial if there's a conflict of interest? You say, well, no, of course not. You have to have a fair, impartial, independent decision maker. Then you ask him, who do you represent in these proceedings? And that's where it's going to come out that he is representing a party, and that would be. But he will do what you and I have to do here, though, Maggie, is trying to deal with the verbal diarrhea that you're going to be getting hit with. I know that was a hell of a visual. Yeah. Didn't think that out enough. But it's all the excuses because when you ask him, who do you represent here, he knows what you just did. You just boxed him into a corner, and now he has to contradict himself, and he doesn't want to do that. So he's going to start making statements saying, are you saying there's a conflict of interest, to get you to start answering his questions so he doesn't have to answer yours. And that's why we always say you just ask the question. When he says, are you accusing me of a conflict of interest? Objection. Please just answer the question, who are you acting on behalf of today?
Yeah, and then you would say, I'm no legal expert, but would that be considered a conflict of interest?
Well, right. If he says, I represent the state, and says, well, and you say, well, objection, wouldn't that be a conflict of interest for you to be representing the plaintiff?
Yeah.
You don't say it's a conflict.
What can he say there?
The only thing he can do is try to make an excuse. And then what he'll do here, usually what they do here, is say that you're refusing to plea and they're going to plead not guilty for you and set a trial date. That's what he'll do there.
I pleaded not guilty because, for the arraignment, I said I want a trial.
Why would you do that?
Right? Well, I'm not supposed to do that? I didn't know.
Hold on. We're up again. Well, hold on a second. I have to actually keep track of the clock, Maggie. There's a real problem with the feed. My name is Marc Stevens. We'll be back with Maggie in just a moment, so please don't go away. Yes, welcome back to the No State Project. I am Marc Stevens. Glad to be back with you here on July 1st, 2017 from the Fortified Compound in Mesa, Arizona. We're talking with Maggie, who's also in California, talking about cross-examination and why we're asking certain questions. And we were just talking about the conflict of interests. And I apologize. I know we're having an issue with the stream. So whatever you missed with me speaking with Maggie, because we went way off there, you can get that on the podcast later today. Calvin, we'll get that posted. And I'll have it on my YouTube channel, hopefully by Monday morning. Anyway. Welcome back to the show, Maggie. So, do you have a pretty clear understanding about why we're asking those questions and why they don't want to answer them?
Yeah, but I'm still not clear about what's supposed to take first. If I actually have to start questioning an officer, which ones do I start with? What is his weakest point? And in answer to your question, why did I plead not guilty? Because in Stanislaus County, at least in California, the whole traffic court has been like mechanicalized or whatever. You go in there and they basically force you to say you're not guilty, you're guilty, or and you want either trial by declaration or a trial by where the officer actually shows up, right? So that's the way I'm understanding it, and so I said not guilty. I want a trial.
Well, are you? So you're not familiar with the tactic that we have of going in with an unsigned plea of guilty and let them know that your intention is to plead guilty? Has the prosecution met their prima facie burden on jurisdiction? Because if they're going to,
that's not something option that they give you, But unless I had heard it from you, I wouldn't know that, right?
Well, it's just like they say. Look, they're liars. They're crooks. And proof that they're lying is when they say, you have two options and two options only. You plead guilty or you plead not guilty. There is option number 3, and that is you can file a demur. It's right there in their sacred code. You can file.
I did file that.
I'm just pointing out that when they tell you what the options are, it's usually a false choice. They're leaving out door number 3, 4, and 5. And they do that on purpose because they're criminals. They are the lowest of the low. So keep that in mind when they say all you can do is A or B. There's usually another option. So what we do when they force the situation like that, so that we can get evidence against them, if they choose to do the wrong thing, we want to be able to prove that they're liars. We want to prove that they're crooks. So when they force, look, it's guilty or not guilty. I intend on pleading guilty. Has the prosecution met the prima facie burden? So what they do is, if they refuse to answer the question, you're not able to answer and give a voluntary and intelligent plea. It stops them from having any legal standing to enter a plea for you, because the only times that these predators can do that is if you refuse to plea or they cannot ascertain their plea. So both those things are not going to be able, they're not going to be able to show either one. The only thing that these people can do is turn around and in a fit of rage is accuse you of playing a game. That you didn't want to plead guilty, you were playing a game. And that's BS, because the prosecution has a prima facie burden at arraignment also. It's not just a pretrial, it's at the damn arraignment. So just a little bit of background, so bear with me for a second. When they charge you with an actual crime, let's say a felony, you have, unless you're indicted, the indictment takes care of the probable cause to then hold you over for an arraignment and trial. If they don't do that, they have a probable cause hearing so that you have a short, like a mini trial before you even enter a plea. So it's just lie after lie after lie after lie that they do to you. Okay, so keep in mind, if you get anything from our discussion today, it's assume that everything that's coming out of their mouth is a lie. Okay? And challenge them on it. Now, none of that means that if you do it this way, real quick, if you do it that way, that they're not going to just enter a plea of not guilty for you. But we do have paperwork.
How can they possibly enter a plea of not guilty if I've already said that I am not, guilty if I already said I'm not guilty? How can they do that?
Because
they can do it anyway?
Because the answer to that is the same answer to your question earlier, is like, why won't they let the police officer answer? They don't let him answer the question because there's no legitimate, valid answer to it that makes the prosecution's case sustainable. So if the judge was to answer the question directly to you, yes or no, either way he goes, he's digging a pretty deep hole for the prosecution, and he doesn't want to do that. If he says yes, you're going to follow up with what specific facts has he pled showing that the Constitution applies to me just because I'm physically in California, and there's nothing. If he says no, then, well, no, if the prosecution hasn't met their prima facie burden to this point, then it should be dismissed, shouldn't it?
Yeah. You'd think.
Now, so what do you do? Well, Mark, what if he says no? This has happened. This has actually happened.
Yeah.
Where they say there's no evidence and they refuse to throw it out. Now, at least you've got the judge's own statement to use against him. So you can, in California, if they don't dismiss right then and there is no appeal from a denial of a motion to dismiss. You can take it into the higher court on a petition for writ of prohibition to review that and stop him from proceeding. But you can also move to change the judge based on the record, his own testimony or his own statement. He's proceeding against you without evidence. So a follow-up question would be, objection, are you telling me, let me see if I understand you correctly. The prosecution has not met their prima facie burden and you're going to proceed anyway. So you're proceeding against me absent a shred of evidence of jurisdiction, correct?
Yeah.
By this point,
he doesn't want to really say.
Well, of course, he's not going to want to answer. He's going to be threatening you with.
He's done that, though. They have done that. They have gone ahead with it, right? I mean,
well, you pled guilty. I mean, not guilty though. You said you pled not guilty because you felt that's all you could do at that point.
Yeah.
It's not the same as the judge. Well, you haven't filed the demur yet, have you?
Yeah. Well, you mean the when it was in the templates? Yeah. I haven't mailed it off to the courthouse yet, but I did mail one to the officer.
Okay, well, you got to get it to the court as soon as possible.
Yeah, I know.
And if you can, have it set up for a hearing, because the demur should be in prior to a plea.
Okay.
I know, but it's the whole thing that they lie that it's not a part of the procedure. No, that's not true. You can always file a demur or a motion to dismiss.
All right.
So,
all right.
I suggest you do.
All right. Well, okay. Bottom line, where do you recommend that I start with if a police officer and question him? Which one of these options do I start with? With the jurisdiction?
Well, we'll talk about the cross-examination on the other side of the break. So just hold on. My name is Marc Stevens, talking about cross-examining a police officer. Where do you start with that? Considering you don't have much time, we're going to go right for the foundation of the prosecution's complaint, and we'll talk about that when we get back in just a few moments, so don't go anywhere. Yes, welcome back to the No State Project. Quick note, because we had that commercial again about the Free State Project and that line about there's a lot of talk about liberty and principles, but they're actually doing it. Yeah, right. Certainly not those folks who get from the Free State Project that got elected to the state assembly. Didn't do a damn thing. So look, take everything with a grain of salt and verify it for yourself. But this thing about the Free Staters. There's maybe a handful that I'm aware of that actually have done anything to advance the cause of freedom, and certainly not the politicians. That is something that we can show. The politicians, when given the opportunity, did nothing. I expect that, obviously, from the executive council. I get that. Why would they do anything to help? Well, it doesn't matter that the agents didn't have a shred of evidence and admitted they had no evidence. Why should the executive council do a damn thing? Why should these politicians, whether they're part of the Free State Project or not? So please, everyone, understand, it doesn't matter if they're Free State Project members. They're not going to do a damn thing to lift a finger and do anything to stop government abuse. They'll do nothing. They have the opportunity. We reached out against my better judgment to do anything by asking a politician for help. And they met my expectations. They did nothing. Damn impotent. It's exactly what they are. That's a politician for you. So we get back. We're talking Maggie. We're talking with Maggie in California, talking about cross-examination. What do we do when we're talking? Well, first, before you get into the cross-examination, okay, you should be objecting to the police officer being put on the stand because the police officer has to have personal first-hand knowledge of the matters he's testifying to. That's Rule 602. In California, I don't think that they adopted the federal rules, but I don't know the number off the top of my head. no one may testify unless evidence is introduced to show that they have personal knowledge of the matter, and evidence of personal knowledge could come out in their testimony. But their testimony is not supposed to be a surprise. That's supposed to be the subject of cross-examination, what they're going to be testifying to, which has to be disclosed to you. So make sure that you have your discovery request with the demur and the judicial notice already sent down, because the discovery request is very important for when you're getting to your cross-examination. So you're going to be objecting to him doing that, and the prosecutor should, if there is one, should be arguing that the cop is competent. Hell, the cop may be the one saying he's fully competent to do that, and he's lying. At that point, he's lying because this is something you've already asked him in cross-exam. You've already asked him for that information in the discovery request, and he should have disclosed it to you, and he didn't. So they're going to put him on the stand anyway. You have to make sure that you know your objections and you object properly and often to his testimony. So now when it gets time for your cross-examination, I suggest the two questions that you start it with are going to it may actually end it there. And the first question you have to ask is you have to set the relevance for the next question. And let me repeat again, you should always be asking leading questions on a cross-examination. Do you know the difference between a leading question and a non-leading question?
Probably not.
Okay. A leading question is a yes or no question where the information you're trying to elicit from the witness is in the question. A non-leading question is an open-ended question where you may not know the answer to it. So the example that I always use is when you got to the victim's house, what did you do next? That's a non-leading question. That's a great question or an appropriate question on direct. So the prosecution can ask him questions like that. The information has to come from the witness, not from the one asking the question. But on cross-examination, so if the prosecutor asked the police officer a question such as, when you stopped the defendant, were they cooperative with you? That's a leading question. You should be objecting leading. Okay, so a question on cross-examination that's leading would be after you got. I'm mixing myself up here. On cross-examination, in a leading question, you put the information, like I said, into the question, just like I did. So that, in a nutshell. All right. So back when we were talking about the conflict of interest, it's a leading question by asking him, wouldn't it be a conflict of interest if you represent a party? Instead of asking, you say you control the answer that he can give you.
Okay.
So the questions that we're asking here on cross-examination, the first one is your setup question. Did you determine on your own that just because I'm physically in California, your laws apply and you had jurisdiction to stop me and give me a ticket?
Yeah, and he'll say, yeah.
Yeah,
right?
Of course. They'll let him answer that question. So your follow-up, now this is where you've got to hold on to your butts. Mr. Officer, what evidence, if any, do you rely on to prove that just because I'm physically in California, your Constitution applies to me? That's going to make them go. They're not going to allow him to answer that question because he has no proof. And
so if they're not allowing him to answer it, what happens? Is that?
Well, keep in mind what's going on here. You have when the prosecutor makes the objection, you have to be calm and say, "Excuse me." He's objecting to the competency of his own witness. Didn't he insist on putting this witness on the stand a few minutes ago? Did he knowingly say? Sir, I object here. I believe that this prosecutor knowingly put an unqualified witness on the stand. And you let him do it over my objection. See, if he doesn't have the personal knowledge, if he's not qualified, and you've made all your appropriate objections prior to him getting on the stand, the prosecutor is now guilty of committing a crime. You've now proven he knowingly put that scumbag on the stand.
I don't think they have a prosecutor in traffic court here in Stanislaus County.
Well, they might. They might with this paperwork. We always assume. It may be the cop. You may be going and butting heads with the judge. Say, look, you insisted that this witness was competent, and you put him on the stand over my objection. Now you're saying he's not. Which one is it? Make up your mind. Is he competent or is he not? He may say...
He doesn't have first-hand knowledge because... Of what reason? Because he was there. He saw me. He saw me driving without a seat. But that's not first-hand knowledge.
Does he? Remember, that's not all he's saying. He is testifying you broke the law. And he has to have personal knowledge that the Constitution or the laws apply to you. His position, that's why we asked that first question. The first question is, did you determine on your own that just because you saw me in California that your laws applied and that there was jurisdiction to stop me? And he said, you said, that's testimony. He is confirming what he did on the stop. It's all relevant to a cross-examination. They may lie and say, he is not here to testify to legal conclusions. He is here to testify to the facts. I only asked him for the evidence he based his opinion on.
Okay.
You see, there's a very sound logical basis to this, and the reason why they get upset and do what they're doing to you, Maggie, is because they're crooks. You are catching them in their contradictions, and they don't like it because they're not there to determine whether the officer was correct. They've already determined that. They're just there to put on a show for you. But we'll finish in the next segment. My name is Marc Stevens, listening to the No State Project here on LRN.FM. We'll be right back. Welcome back to the No State Project. Sadly, Hallowed Be Thy Name was not played at the Maiden show, which I was expecting. If I was to just go to a show and all they played was Hallowed Be Thy Name, it would be worth it. But sadly, it was not on the playlist for some stupid court reason, I don't know. But welcome back. We're talking with Maggie in California, and I appreciate everyone calling in and being patient. We got really important issues to get to here. It's always important to discuss cross-examination because you have to prepare as if this is going to go to trial and you're going to have to cross-examine a police officer. And boy, will they pull out the lies for you on cross-examination. And so, Maggie, one of the things we mentioned before is they'll lie to you and they'll say he is only there to testify to the facts of what happened at the stop and he is not there to give legal conclusions. And yet, didn't he give legal conclusions at the stop and on the ticket?
Yeah.
I'm kind of losing your volume there.
I'm losing my voice.
Your volume is really low right now. The background noise is loud. Okay, I guess you're on a cell phone. It sounds terrible.
I am on a cell phone.
Yeah, I can't make out any of what you're saying.
Well, really, just that.
Yeah, so I'm going to have to. Let me finish. I'll finish off air. If you can give a call back, give it a shot. But it's just it's unintelligible. I can't make it out. So I apologize for that. These are the things that we have to expect from people who have made up their mind prior to you coming in. Don't let anyone kid you. Don't listen to any of this trash that people will say that judges are fair, impartial, and independent, and that they don't make up their mind. That might be true in real criminal situations. That is not the case in traffic court. Traffic court is to separate you from your money. That is it. They are criminal organizations, and and the courts are run by crooks. They are only there to make it look good if they can and to take your money. And even if they can't make it look good, they don't give a damn because they are still going to get your money. They are still going to get your time. And even if they are overturned, they will not lose a moment's sleep and they will not lose any pay and they will still be voted back into office or appointed. They don't care. They don't have to because they have a prison system. So these are the things that are going to come out. So when the judge is doing this, you have to calmly make your objections. Objection. Didn't he make a legal conclusion when he wrote the ticket? Didn't he make legal conclusions prior to this? Didn't he just testify and provide a legal conclusion to my first question? So there it is. And then what it comes down to, this is for Maggie and everybody else. They are actually saying that the witness for the prosecution, the sole witness most of the time, is not qualified to determine you violated the law because he's not qualified to determine it applies to you. If he is not qualified to give legal determinations, then he is not qualified to say you broke the law. Obviously, he doesn't have personal first-hand knowledge because the evidence isn't there. And not only that, he's not qualified, and the judge is the one saying it. And that's the thing. If you or I say it, it carries no weight. Nobody cares if you say or I say the cop is not qualified. But the judge is supposed to have some credibility there. He's the one that everyone is revering. Well, the judge said the cop wasn't qualified, which is why we're so effective on appeal, because the judge is the one determining that the witness is not qualified. And he's taking the testimony anyway, and he's not permitting further cross-examination. Denial of cross-examination without waiver is a constitutional error of the first magnitude, and no amount of showing a want of prejudice would cure it. Now, I only say that because that we're bringing out a contradiction. It doesn't mean I believe that the Constitution applies to anybody. I'm just showing that they believe it does, and they contradict it. And getting people to contradict themselves is a way to impeach them. It is a way to discredit them. So my quoting the Constitution, my quoting Vlandis versus Klein, is not saying that all of this applies and is valid. It's just to point out a contradiction. That's it. That's it. All right, we're gonna go. We're gonna go to the other side of North America. I believe we've got a new caller from Jersey, area code 732. You're live on the No State Project. What's your name? What part of Jersey are you calling from?
I'm sorry, James. I'm from New Jersey.
James from Jersey. How you doing today?
I'm all right. I'm pretty good.
So what do you got? What's going on?
I got a couple questions. I'm doing my court thing. I was being brave and bold and trying to do my part in activism by proving that you don't need a driver's license or anything like that. I got pulled over. The officer gave me 7 tickets, and I'm in my 4th arraignment. And in my last hearing, I was in the prosecutor's office, and I was going back and forth with him, him giving me the runaround. And I finally got him to say, yeah, I didn't submit nothing. I have nothing. I've got nothing. I didn't submit anything. So I said, all right, so we should move to dismiss, of course. We walk out the office, and they said, all right, so we're going to wait for you to be last, of course, to intimidate me, all the officers there. So then I went out for a cigarette. I came back in. They said, wait here. Judge is talking to the prosecutor, having a meeting. Ex parte, probably. So I walk in there, and she said, all right, this is your trial now. I'm like, wait, I was just at arraignment like 3 minutes ago. So now I try to cross-examine the officer with the questions that you said earlier. They sustained them all, and I forgot to stand up and point that out, so I kind of messed up on that part.
Okay, wait. So let's not get. We got a lot of time here still. There's a lot of. I know you Skyped me before during the show, and there's a lot going on here. I want to point out to people that it is a major due process violation and seriously unfair for them to go from an arraignment in a criminal proceeding, even if it's a misdemeanor, a petty misdemeanor, to go from an arraignment straight to trial. There's a basic laundry list of objections that you could have here. Now, that doesn't mean that things would have been any different. If you're at arraignment, and there's a reason why someone's going through so many arraignments. If the prosecution had the evidence, they could get through it. But here, you have an entire pretrial procedure and proceedings that were neglected, right?
Yeah.
I know we're coming up against the top of the hour break here, so just bear with me. I can't imagine, though, James, that any critic would be able to turn around and use my being a schmuck from Long Island or being an anarchist as some valid reason why in a criminal proceeding they would skip the entire pretrial process and somehow say that that's fair. No discovery, no Brady material in a criminal proceeding, and still try to. They will still be critics that will So take the jurisdiction issue completely off the table. We're not even talking about that. We're talking about the pretrial procedure and discovery and Brady, and there will still be douchebag trolls out there that will say Mark's an idiot. Don't listen to him, or unless you're an idiot too. And everything he says is complete garbage. They don't have to give you a any pretrial. Let's just say, for sake of argument, though, James, let's just say it's similar to New York on the pretrial procedure. That does not excuse a denial of Brady material, which is pretrial also. So, did you get any Brady material? Did you get any response?
I got nothing. I filed the motion to dismiss with me that hearing. I brought it with me and filed it that morning. Like, as soon as they opened their doors, I went in there, filed it, everything for the proceedings. Because it's a small town court, and they only have court once a month. And I've called the prosecution office, and like they don't return my phone calls back until like the day before or something like that. So they're definitely trying to screw me over. And every time I leave that.
Well, hold on, James, we're up against the top of the hour break, so I got to mute you up. So just hold on. We'll continue this on the other side of this break. My name is Marc Stevens. You're listening to the No State Project here on LRN.FM. We'll get into the third hour of Anarchy Radio in just a few minutes with James from New Jersey, straight from arraignment to trial. How about that? Boy, the wonders never cease. And there'll still be some that say that that's fair. Welcome back to the No State Project. This is the third of 3 hours of Anarchy Radio, and anarchy, of course, being no rulers, not no rules. The rule primarily being aggression is wrong, do no harm. Very easy to understand, and that's why when we talk about government and why there is no government, basically because the contradiction that we mentioned before, that we bring out contradictions and show that somebody's position is not credible. They contradict themselves, which is why inconsistent statements are a way to impeach a witness if you are in court. So the contradiction is that the means are not consistent with the end. It's very simple, that they're supposed to be protecting life, liberty, and property. That's the stated end. But the means, the fact that they force everyone to pay them, violate life, liberty, and property. So the means contradict the end. You have, and that's why. You shouldn't have to say anything more than that. There is no defense. There is no defense. There is no overcoming that. And if anybody thinks that you can overcome that, 218-632-9399, passcode 2020, or Skype me at FrankRizzo3, and we'll hash that out. I want to bring back, talking with James in New Jersey, and they do have pretrial discovery in New Jersey. So there's supposed to be a pretrial conference, and there's always supposed to be Brady, and you were completely denied any of that. And did you object and say that you... Obviously, especially as a layman, that you need time to prepare for trial? That you only showed up for an arraignment?
Yes, I stated like I wasn't even prepared for this. You're forcing me into this trial right now. And of course she said, no one's forcing you. So I said, so if I left right now, what will happen to me? And of course, she just said silent. And then started talking about something else completely different afterwards.
Isn't
so I
that
waited
nice?
for her to respond to that.
That's the typical scumbag politician. I'm not. If they should have done like one of those, in Congress. I'm not taking questions today. They just sat mute.
Yeah.
Ay, ay, ay.
Yeah. So I actually can I at least come back? So I since I have to deal with this now. Since you threw me into this thing. I have to find witnesses, subpoena people. I don't even know how to even proceed with a trial. Like I just basically told them. And so she just sat there with a smirk on her face and said, "All right, go ahead and we'll schedule this for next month." So whenever I leave that courtroom, also I want to point out, like whenever I leave that courtroom, the officers follow me. So and like they follow me 3 blocks while I'm walking. I get into my Uber. They follow my Uber outside of the township. And every time I go there, they do that. To try to scare me.
Wow. Gee, well, well, you don't have to. I mean, what part of New Jersey? Give us an idea. You don't have to say the actual town if you don't want to, but can you give us an idea?
The town, I'll tell you the town. It's called Winfield Park. The town the courtroom I'm going to is called Winfield Park. And the location is the Union County area. So it's a small little, like mile-long little town that they have.
So I have no real reference to that. What big city is near there? I mean, Newark or
Elizabeth, Newark. Yeah, Newark is about 20 minutes away from here.
So you found a place that's you found a court that's basically than being in Newark.
It's near Newark. Yeah, it's 3 minutes away from my house. I'm 20 minutes from Newark.
Oh. I was trying to make a New Jersey joke. So none of my jokes are they're all falling flat today.
Sorry.
Okay. The first time I saw Iron Maiden was in the Meadowlands.
Oh, good theater.
Yeah.
Please.
I saw the Who at Giant Stadium.
Mm-hmm.
But anyway, so when is the actual date for this trial?
The 11th of this month.
Holy crap.
So I've been preparing, and I just bought your motion for the demurrer. So I was going to follow that as soon as I get it. And I was wondering if there is anything else I could do to try to help me with this, because I'm trying to, if you could email like questions I could ask for cross-examination or something like that.
Well, I do have a script with that.
To damage control it.
Yeah, I do have a script for that available also that I can send you with the motion. Well, in New Jersey, for those listening, very few places still call it a demurrer. California and Kentucky are one of the few. New Jersey is called a motion to dismiss, like most other places. Changed it about 80.
Okay.
So anyway, what you're looking at is filing a motion to dismiss with the discovery request, because that, unfortunately, is something that's going to have to be done right before the trial, that they're going to have the evidence. And so you have a number of issues we're going to get to. One of the big ones is, because you're sitting there at trial, is the prosecution there's a Brady request that has been violated, that there's a Brady violation, that he has not given the name of any witness with personal knowledge that of his claims that the Constitution laws apply just because you're physically in Jersey. He's given no evidence whatsoever to support that claim, not a witness and nor any evidence. So we have a discovery and a Brady violation there. Now, he's going to fight you, and he's going to say, he may do like what this guy did up in New Hampshire I've mentioned before. He may want to give an offer of proof that the witness does have personal knowledge. And you have to object. Objection. Personal knowledge of what? What is he planning to testify about? This is what discovery is about. What he is bringing, what he's testifying to is not supposed to be a secret. So you have to.
Yeah, I'm supposed to have that knowledge of that, because the fact that you dragged me in here, I should know everything you have against me.
Of course, that's why they were arguing in that in that TV clip I played earlier regarding the tickets with the messages from the police, because the judge is getting information that you're not getting, and that information is going towards the judgment, and you're not able to defend against it. So when you get in, you're going to be having to discuss the motion to dismiss and the lack of discovery, and you'll have to, you can get this from me also, probably accuse and you'll have the evidence though, accuse the prosecutor of misconduct, that they are arguing without evidence. Now, so one of the things we talk about a lot is they'll, like critics will say, is he doesn't need evidence of that. So you have to object. Again, everything you're objecting to, you're going to say objection and ask a question usually. Objection, let me see if I understand this correctly. The prosecution is allowed to argue without evidence against me. Really? And so you have to snap back with a question. Do I get to argue against the prosecution without evidence?
This is show a mockery of that statement that she just or the judge said.
But you have to get
mockery of it.
Well, yes, and more technical is you are bringing out a contradiction. You want them to contradict themselves. Well, wait, why can the prosecutor argue against me without evidence, but I can't argue against them? What's the difference? Oh, that's right. He's on the same team as you. You both work for the state. I can see the bias right there, a political bias. So they again, the common lies we discuss all the time on the show that you'll hear is jurisdiction is a pure issue of law. They don't need evidence.
Yeah.
And then, of course,
everyone knows it.
Yeah, and then they'll turn around and lie and say jurisdiction's a trial issue only. That's something that we brought up at trial. That's what we're here to do. Which one is it? I mean, I'll say it till I'm blue in the face. If it was a pure issue,
when you do,
I was just going to say, if it's a pure issue of law, your physical presence in New Jersey would be completely irrelevant to the issue. That's the way it works. It's either a pure issue of law requiring no evidence, or it's a practical application of law, and it does require evidence. This is something 5-10-year-olds can understand. They understand it, but they don't want to admit that you're right because it makes them look bad. Your Honor, I object because it's devastating to my case. We'll be back in just a few moments with James in Jersey, so don't go away. Welcome back to the No State Project here on LRN.FM. I'm Marc Stevens, the author of Government Indicted, which has a full model on how to effectively defend yourself, available as an ebook also. And what we're talking about is objections and why they are so adamant about not answering certain things, and why they object to questions that we put to their witness. And so I've played it on the show before. Let's just hear this again.
Your Honor, I object.
And why is that, Mr. Reed?
Because it's devastating to my case.
Overruled.
Good call.
Of course, one of the best scenes from Liar, Liar. That's it in a nutshell. And the reason why we make an objection, though, to having their witness put on a stand is because the witness doesn't have the personal knowledge. We've gone through the pretrial procedure, and we know the witness isn't qualified. And so according to the rules, which are supposed to make sure that it's a fair trial, they're not permitted. But they'll put them on the stand anyway. Why? Because they're dishonest pricks. That's I know that's an insult, but you know what? They deserve it. Look what this guy did to you. Look what they did to you. Look what they've done with that Dick Noble and Michael Cox, what they've done to people. They're dishonest crooks. So you've got a lot, like you've got 10 days to prepare. So definitely get the motions in, the discovery, and you should be focused. Your role playing, of course, should be focused on obviously when you first get there to stand on the motion. And they bring out the Brady violations and the pretrial discovery violations.
So definitely point that out when I go there. Just like go in there, like, Judge, there have been several violations here, due process violations and Brady violations, pretrial violations from the prosecutor for the fact that you threw me into the trial without any of these, without any preparations.
Yeah. And now, even though you've had the time and you've given them the opportunity to respond, you still don't have the information. They're supposed to have that right then and there, and they're not going to. And Brady is a continuing obligation. The prosecutor, so let's just say, for example, they try to make a claim like, he's just making his claim for personal knowledge now. It doesn't matter if you make it the moment before the trial. He's not supposed to have and seek to have this go to trial if he doesn't have qualified witnesses. There's supposed to be an investigation that goes on to determine whether there's sufficient evidence to prove all the elements beyond a reasonable doubt. You don't wait until the day of it. All that's supposed to already be done. Otherwise, the prosecution is pushing for trial without such evidence, and that's called misconduct. That's a malicious prosecution. When you know, or if you turn around and you just blow off the basic prosecutor's responsibilities to make sure that you have evidence and qualified witnesses. This is basic common sense stuff. So he doesn't have a leg to stand on. That's like all these prosecutors, like Chris in Connecticut, who I haven't gotten the information yet from. They wanted 90 days. What in the world would you need 90 days for to do it 90 more days to meet your prima facie burden? That's an admission you haven't met your prima facie burden because, James, it's all we're doing is asking them to meet their prima facie burden.
Yeah.
And so if they need 90
burden of proof,
if they need 90 more days, that is an admission that they have not met their prima facie burden, that they have actually come after you without sufficient evidence. Jeez, some of these people.
And while we're in this so-called trial, they were because they also gave me 7 tickets. So it was like one was driving while suspended. So the judge asked the prosecution what was the date for his first suspension, and the prosecution didn't have a date. And he's like, "There's no date here." And I caught on to that, and I pointed that out. So there's no date for that. So how am I suspended? There's no date for that in their records. So she dismissed that ticket right then and there. She just jumped on that right away, dismissed it, and just continued on to the others, and trying to scare me into making them enter a plea.
Right.
Well, she put a plea in on my behalf anyway, and I'm still trying to question that. Like, I didn't enter a plea. I'm just trying to plead guilty.
Well, and you could do a motion to change the judge and point out, and in the article I wrote that accompanies the video, because the judge the judge is lying to cover the prosecution's lack of evidence. They're lying by implying that you were refusing to plea when, of course, you weren't doing that. We spoke about that earlier on the show. A very common lie that they do. It's just out of frustration that they've got one who can see who's not accepting a sacred cow for the prosecution. So when you ask for their prima facie evidence, and if they have it, you'll just plead guilty, and they turn around and say, not guilty, we'll set it for trial, that's a big F you. We don't give a damn that you want to know if they have their burden of proof met to this point. We don't care. We're just going to go, and she used the word she was using. I think she was from California, Maggie. I think it was automation that she was saying. It was too mechanical. It's automated. It doesn't matter if you're trying to plead guilty. If you ask them for proof, they take that as, screw you and your proof, okay? You're going to trial.
Mm-hmm. Pretty much, just force you into it because they have no other way to deal with me. I think that's what the main thing is. Like, they know I'm not going to conform. I'm not going to be like scared or anything like that because I'm so nice when I walk in there. I'll say hi to all the cops and all that. Just to show I'm a harmful guy. I'm not vindictive. I'm just trying to get this resolved. And if he doesn't have the evidence, whatever. And the prosecutor, one prosecutor, I went through 2. One asked me if I had a driver's license. I said, I'm going to exercise my Fifth Amendment right and not say anything to you about that. And she kind of looked at me like, you need to go talk to the judge.
See, when you speak with the prosecutor, this is for everybody. They ask you a question like that. You always fire back with another question. Excuse me, do you have any evidence whatsoever that your code applies to me and I'm required to have a driver's license in the first place? Any evidence at all? Any. Give me something. You don't. So if you have no evidence that your laws apply to me and that I'm required to have a license, what's the relevance of your question again?
Yeah, pretty much.
Yeah. We have to always keep in mind that we have to stay focused on what's relevant. And whether you have a driver's license is completely irrelevant to whether there's evidence of whether there's jurisdiction to stop you.
Mm-hmm.
Because they'll even admit to you that whether you have a driver's license or not is not relevant to whether they have jurisdiction. Because if you didn't have a license, they'd still give you a ticket and charge you and prosecute you.
Yep, even if I did have one, they still do the same thing.
That's that criminal, Ray Persinger, begrudgingly and in a rage admitted it when he tried to claim. That's what they try to do. They try to use your statements. They try to use what you have done, usually on the threat, duress, and coercion, against you. Well, sir, you have the driver's license. Well, wouldn't you charge me if I didn't have it? Well, yes. Well, then what possible relevance is what I did on the threat, duress, and coercion relevant? It's got nothing to do with their foundational claim. So we have to stay focused on what's actually relevant. So when they ask us those questions, we don't answer. We bring it back to, do you have the proof or not? We're up against another break, so just hold tight, everybody. My name is Marc Stevens, talking with James in Jersey. We'll be back in just a moment. Yes, welcome back to the No State Project. I'm Marc Stevens. Remember, Jack Fest 2017, July 31st to August 6th. And I will be there. It looks like Calvin will be, so it should be a good time. So if you're going to be in Arizona that week, definitely try to make it up. We'll definitely make it up for at least a day. It's a nice trip. It's beautiful up there. It's a lot cooler than Phoenix, about 30 degrees cooler. So definitely a good time. Check it out. And most of our anarchists are not the type that, hey, let's get elected into office and then we can bring liberty about. No. You take liberty. It's through nonviolent non-cooperation. It's by exposing them for the criminals that they are. And I'll talk about that more in the last segment. But we're talking with James, who's got a lot to prepare for. He's got a so-called trial coming up on July 11th in Winslow Park in New Jersey there. So I trying to remember, we're talking about all the lies and things that you're going to hear when you get in there and what you need to do to prep for it. I recommend definitely, I think you're already in there to do the role playing, so definitely do that. And just remember the basics. And so when you're doing the role playing, remember the basics. You're just.
I usually do that. I've been doing a lot of role plays.
Good.
I'm always trying to get one going.
Wait,
probably annoying people.
Hey, you got to get it done, and I know we've got 345 members. Obviously, not everyone's participating, so I'm gonna have to clear some out. If you want back in, and I do it by mistake, and I didn't realize that you were active, you can have someone bring you in, or I can bring you in. It's nothing personal. But the basics are. We're asking questions to bring out contradictions, and we're basically safe to assume that everything that they are saying is a lie or some kind of diversion tactic. And so when they start asking us questions, that's usually not good. We don't want to answer their questions. The only reason why we're asking very simple questions, very simple but very effective leading questions, and they just don't want to answer because they don't have the proof, and they don't always want to lie and say that the prosecution doesn't need the proof, because that just opens up another can of worms. Because, like we mentioned already, you're bringing up a double standard.
Yeah. And you try to bring in, that's the guy I remember leaving. I made sure I got this information before I left the courtroom. Does the prosecution still have the burden of proof? And she said yes. So I know I don't have to make any claims at this point yet. So I can still question jurisdiction next time I go in. So I will just go in with the motion of Brady material, go on the fact that all of these violations happened and occurred, and the prosecutor still has yet submitted his burden of proof, or met his burden of proof, and push for the dismissal on all those grounds.
Yeah,
wouldn't that be a good way to go about it?
Well, yeah, that's your focus. Your focus is the motion to dismiss and the missing evidence, of course, because the motion to dismiss is based on a lack of evidence that regardless of the claim that jurisdiction is a pure issue of law, we have them saying just as many times that jurisdiction's a trial issue. We even have from Marc in his New Jersey appeal, the judge flat out says that jurisdiction must be proven at trial. How is that? People are just trolling us at this point because we've already done the issue to death. And for anyone who's not accepting it, they're either being paid not to or they're too mentally deficient to grasp such simple concepts. And so there's a major contradiction there. Look, I've said it before. Burke up in New Hampshire is on video saying it's a trial issue. And yet they still want to maintain that it requires no evidence? Please.
Even when you're in trial, they try to even hide it. So, that's the odd thing. If it's a trial issue and you're in trial and you bring up jurisdiction, they still do the same tactics. Like, we don't need to prove it. Like, but you said it was a trial issue. So I'm in trial. Why don't you have it now?
Well,
you brought me here to begin with.
What some of them will do is they'll try to limit the scope that all they have. This is what the Jarnins. I know I'm mispronouncing. That's what the judge said recently with Bill. All they have to do to prove jurisdiction is prove that you were physically here. And my objection, how exactly? And this is something that should come out on cross. If they pull that crap, please tell me how this written instrument applies to me just because I'm physically in New Hampshire. Tell me.
Yeah. And I went for that question when they tried to attack her with me with the officer's testimony. Because the prosecutor said, all I need is the officer's testimony. So I'm like, all right, so does he have first-hand knowledge of, like, how these statutes and codes apply to me? And he kind of just veered off that question. Or I'm not sure if he said yes, this to intimidate me, or just BS around it. I'm not sure. I can't really remember. But and the officer in the court, when I asked the question, sustained, no reasons whatsoever, and the prosecutor said objection, and it just said sustained. No explanation whatsoever, just went along with it.
They didn't even say what the objection was or give you an opportunity to respond.
No.
Yeah, you see, that right there is as clear an example of something being unfair as you can get. Do you think for a moment the prosecutor would have sat still if you made an objection to what they were doing, you didn't identify your objection, and they just granted it? The prosecution, excuse me, with all due respect, we need to revisit this objection. I have something to say here. Oh, my God. So, and that's another thing you can watch. There's no way in the world that when you make objections, you're ever going to have one sustained by the judge with no input whatsoever from the prosecution. And you're damn sure going to be, look, you could bet on you have to articulate the objection. You can't just say you and I have to say objection, relevance, objection calls for illegal or objection, lack of foundation, objection, leading. We have to actually identify what it is.
Yeah, they could just say the word and it's like match it to any needs that they need necessary. Yeah. Basically.
Yeah, and that's because the judge.
Absurd.
The judge is on the same team and is working with the prosecutor. So let's hear it again.
Your Honor, I object.
And why is that, Mr. Reed?
Because it's devastating to my case.
Overruled.
Good call.
and that sums it up, And I already mentioned, but it's very clear. When you and I are objecting, it's because we want only the facts and the truth to come out, and they are doing it like what we just heard. They're doing it because it damages their case. If they had the proof, and it was so damn easy to prove that just because you're physically in Jersey, a 200-year-old written instrument applied to you, they would just spell it out. They just give it to you. Here it is. There you go. Enough evidence to choke a horse. You happy? Can we?
Yeah, that's the most logical thing to do, especially if you want me out of your courtroom and you're tired of me coming back here.
Wait,
I'm trying to plead guilty.
Yes,
you have the evidence. Yes. So I'm making your job 10. I could be out here in like 10 minutes if you had the shit. Like I've been gone.
Show me.
Keep dragging it on and on and on.
Show me the prima facie proof. Show me that he's made the prima facie burden. And I'll plead guilty right now. Whereas, because 90%, I don't remember the exact number. About 90% of cases are pled out anyway. Why should yours stand out? Why should there be so much resistance to you going in there and pleading guilty? And it's not conditional. Don't let them fool you. They have to have that. Look, the prosecution has to have met that burden anyway. So and then you got the voluntary and intelligent plea. Also, if the proof. So keep that in mind when you're doing this, and when you're role playing, when you're going in there. The ones who have, if someone is honest and has the proof, they'll give it to you. So. Hey, I appreciate the call. I'm glad get to doing that role playing. Any other questions or comments you have, feel free to drop them on Skype, and we'll have at least 2 more live broadcasts before you have to go in. So feel free to call.
All right, thank you very much.
Appreciate that. James in New Jersey. We'll be back here with the last segment on the No Say Project. Just a moment. Don't go away. Welcome back to the No Say Project. Remember, of course, we've got in just a few weeks, we got the Jack Fest coming up, and that'll be July 31st to August 6th, 2017. I just want to point out, too, we're still looking for a place here in the West Valley, Phoenix area, Mesa in particular, to do a once-a-month live broadcast, and with a small audience or big, with an audience, let's say. And we haven't found anything, but hopefully we'll get something like that soon. But and I'd like to do a jam out. That would be fantastic. But I did find a place that has a pretty cool open mic jam, and it's Desert Eagle, and it's on Main Street in Mesa. Nice area, though, by the way. And it's right down the street. It's walking distance, maybe 100 feet from Milano's Music. So for those familiar with the Valley, you may know what if you play guitar, you'll know where the place is. I didn't get to jam with the guys. I got in there too late because there were 2 Desert Eagles. I went to the wrong one. So by the time I got to the other one, it was kind of late. And, anyway, so I'm hoping to get there from Tuesday. Every other Tuesday, you go to Desert Eagle, check them out. Desert Eagle Mesa, check them out online. And so you can see every other Tuesday at 6:30 to 10, they have an open mic blues jam. And I'm going to do my damnedest to get in there on Tuesday night. And hopefully get to play a few songs because I haven't been able to jam for a while. But if you're in the area, if you're in the Valley, definitely check it out. Even if I can't make it or I'm not able to jam, the guys there are pretty good. They got a really great saxophone player. Who unfortunately, that's the reason why I didn't wind up playing with the other group, because the sax player decided he was done for the night and wanted to play guitar. I'm like, no. Anyhow, the new segment that I mentioned earlier, I think it's important. I've done it before, and I guess I don't know. I guess I wasn't doing it as a separate series of videos. I was doing them as they came up occasionally, but. I guess it was because my channel got hit with so-called copyright violations. That may be why I haven't been doing it sooner. But I don't know. Maybe something like that will happen again. I don't know. But I think it's important to report the facts of what these people are doing, and to do regular videos. Exposing the criminal and the dishonest actions of these lower-level bureaucrats that people never really get to see. I mean, it's not like Keene. You're in New Hampshire, you get to see some of the lower-level ones because there are some decent activists out there. So you get to see, and you can bring video cameras into court, but not so much in Phoenix. Not New Hampshire is pretty tight, and so I'm gonna do a short video about Greg Ives, because I got a bunch of pictures, and I do have audio recordings. So if there is after I publish, and basically what I'm bringing out is, and I've mentioned it before, his inability to do a refusal to do the right thing with the Twin Mountain Country Store, and causing he contributed to the demise of this business because he absolutely would not do the right thing. And so it's very easy to show how dishonest he was. So what he and I want people to be able to Google or search him on YouTube and get the truth about him. I'm not saying he's a bad guy. I'm even putting a video. I don't think he's a bad guy. He seems like a really otherwise decent guy, but he would not do the right thing. And so what he did, it's very easy to show how dishonest he was and how he contributed to this irreparable harm and injury that he's caused to Bill and his family. Because he stated very clearly, and we have audio proof of this, jurisdiction was off the table. It was not within the scope of the administrative hearing process. And every step of the way, he reminded us of that. And my position was, well, all right, I can accept that if you're consistent. And so right from the start, we pointed out, if jurisdiction is off the table and is not within the scope of the administrative hearing process, you cannot determine that the NHES, the New Hampshire Employment Security Department, you cannot, by your own statement, make a determination that they had jurisdiction. Right? That's fair. If jurisdiction's off the table, then damn it, it's got to be off the table for both sides. And I even said, you are hamstringing yourself. You can't make a decision. He didn't care because the decision was already handed down to him. Now, I don't have any proof of that. The only thing I have is circumstantial evidence. Why would somebody who stated that jurisdiction and the applicability of the law was not within the scope of the administrative process? He had no jurisdiction to make such a determination. Yet, he did it anyway in favor of the NHES. See, I'm not saying this to my general audience. I'm saying this to the trolls. Any 10-year-old understands if you say jurisdiction is not an issue that we can discuss and it's off the table, that means it's off the table. You can't determine jurisdiction one way or the other. You can't determine the law applies one way or the other. It's off the table. But Greg did it anyway. Why? Let's see. Who does he work for? Who's paying him? Who gives him his marching orders? Can I prove he was told to rule against Bill? No, I can't. Does the circumstantial evidence stand against him? Yeah. His contradiction stands against him. He did what he explicitly stated he could not do. There is no rational dispute to that. Zero. And of course, the scumbags on the appellate council, if you can call it that, the panel, said the same thing. Still affirmed jurisdiction, and they all stated he could have that particular issue addressed by the New Hampshire Supreme Court. That was a lie. So to justify them doing what they said they can't do, they gave the excuse that Bill could have that addressed by the Supreme Court. Well, 2 times the Supreme Court told him no. They didn't hear it at all. They voted unanimously not to hear his appeal. So, I don't have any right to do this, but I'm going to do it anyway. And there's no way he can dispute that because we have the paperwork. Well, he can lie, but he doesn't strike me as that kind. Somebody may say I'm taking it out of context. No, we have the audio tapes. I will risk, if I have to, I am challenged on the veracity of what I'm saying now and in the video. If I am challenged on the veracity of my statements, I will go gladly upload the audio for everyone to hear. I will gladly put myself in jeopardy for a potential contempt charge to prove that I am not lying, that I am not taking anything out of context. So I'll put this out and I'll start doing that. So if there's a low-level bureaucrat, and I want to have pictures here, I want people to see them and know who it is. And I don't want them operating in obscurity anymore. They shouldn't be operating like me anyway. People should know who they are. So if you do have a low-level bureaucrat that you have pictures of, okay, I don't want personal information. I just want to know where they work. I want to know the evidence. I want the evidence of what they did, or it's something that I can find out and investigate on my own. But I'm going to start doing this as a regular practice. So Greg Ives is going to be the first one, and so it'll be more than just me and Bill who know what this criminal did. So look for that in the next couple days. My name is Marc Stevens. We should be live on Wednesday. Until then, salud.